appeal in a matter of General Dynamics United Kingdom Ltd versus State of Libya.
Yes, Mr. Desack.
Good morning, my lords. In this matter, I appear on behalf of the State of Libya,
Yes.
with together with my own friend, Mr. Jacob Turner. Neither of us have appeared in the court below.
No.
And GDUK, as I shall call them for shorthand, General Dynamics UK Limited, represented by my own friends, Mr. Joe Smoohar KC and James Ruddell.
Yes.
This is an appeal against a judgment of His Honour Judge Pelling, sitting as a judge of the High Court.
We've read the judgment, we've read the skeletons.
Thank you. Then I'll pass to two preliminary matters. One, timing. Two, a preliminary issue left over from my Lord's order of the 10th of October. Timing, first of all. If it is convenient to you, and subject to what time my Lords would wish to rise, our proposal that we're agreed on is this, that I should speak until 12:45. My learned friend will then have 15 minutes before the short adjournment and 2 hours afterwards, and I should have 15 minutes from 4 to 4:15 for a reply.
Fine.
Is that convenient to you?
Be fine.
Thank you. Second preliminary point, as my Lords know, my Lord Justice Lewison made an order on the 10th of October concerning liberty for us to rely upon our replacement skeleton argument, holding over any such issue that may still arise, I paraphrase, to the hearing of this appeal. My Lords, in the usual way, as one might hope, that issue has somewhat faded.
Yeah, well, there's one point where GDUK say they don't object to your raising it.
Exactly.
Our preliminary view, obviously we hear what Mr. Smoohar has to say about it, is that your revised skeleton or your replacement skeleton doesn't go beyond the grounds of appeal for which you have permission. There may be new arguments which lead to the same result, but they're not new points in the sing and dash sense.
Thank you. Obviously, we'll do it as convenient to you, but thinking of the clock and quite a lot of material or ground to cover in the time available, to be of most assistance to you. We're entirely in your hands how we deal with this, whether we grip this issue now, or you hear from Mr. Smoohar on the point my Lord just made, or whether we just leave it and let it go with the submissions.
I think, speaking for myself, just get on with it.
Good.
Let's hear the arguments, and if there are objections, Mr. Smoohar can make them when it's his turn, and we will consider them in due course.
Thank you very much indeed. I shall get rid of 2 bundles straight away. My Lords, first of all, before coming to the first ground 1, let's make some introductory observations, if I may, please. The parties agree that the issue on this appeal is a short one, and as my learned friend has put it in his skeleton, is capable of simple and straightforward disposition. We agree. But the apparent simplicity of the issues should not obscure, and I'm sure do not obscure for the court, the fact that its resolution has potentially far-reaching and important consequences for the way in which sovereigns and commercial counterparties express themselves contractually in the future. The central question is whether, in the contract entered into with GDUK on the 5th of May 2008, for the supply of a tactical and communications and information system at a cost of some £84 million, governed by Swiss law, Libya waived its rights to immunity from execution under Section 13 of the State Immunity Act 1978. The perhaps key difference...
Is that the issue? Isn't it whether Libya consented to execution? Which is what the statute says. It's not about waiving rights, it's consent, isn't it?
Well, we see it in this way, that the key difference between us is what the final sentence of Clause 32 means.
Yes.
We say it relates to enforcement of an arbitral award as a judgment by national courts. They say it relates to execution of the arbitral award against specific assets. And that appears to be the difference between us. The sharpness of the divide was expressed with clarity and precision by Lord Justice Moore Bick, giving judgment of the Court of Appeal in Svenka on the cases that you will have seen referred to. And can I take, my lords, please, to Authorities Bundle, tab 10, page 234. I'm using the bundle numbering when I say 234. This is a case to which we will return. But I thought it's helpful to have this at the start. On 234, just above E, you will see that what his lordship says is this. The just below margin letter E rather, the State Immunity Act itself draws a distinction between proceedings which relate to the arbitration, section 9, and process in respect of property for the enforcement of an award, section 13. In our view, an application under section 1012 of the Arbitration Act 1996 for leave to enforce an award as a judgment is, as subsection 1 recognises, one aspect of its recognition as such is the final stage in rendering the arbitral procedure effective. Enforcement by execution on property belonging to the state is another matter, as section 13 makes clear. And we submit that is a helpful starting point for the divide that is between us. This word might be helpful about the parties' respective positions. Of course, everyone knows what the State of Libya is. But it will not be overlooked that the respondent is the UK subsidiary of General Dynamics, one of the world's largest arms companies. In the normal course of its business, it must regularly conclude contracts with states. And GD UK could have drafted a clause making abundantly clear that Libya had waived its immunity from execution, had, as to my lord's point earlier on, consented to execution. And there are many examples of acceptable formulations to be found in the textbooks and case law of recommended language for these purposes. My lords have seen in the skeletons we cite some, so do learned friends, and you'll be familiar with all that material. Instead, the claimants rely on the vague phrase, final, binding, and wholly enforceable, which appears to be unprecedented, as the judge noted in granting permission to appeal. In these words, I gave permission because the language used is somewhat different from that used in the reported cases, which is a considerable understatement, if I may say so, with respect to him, but equally correct. We say that the judge was right to find that fact, right to grant permission to appeal, and we submit that such language as was used is insufficient to abrogate the fundamentally important sovereign right to immunity from execution. I'm going to pass quickly over the background, which my lords have seen doesn't gain much from oral repetition. But there are two key sources, both of which my lords will have considered, upon which we draw in seeking resolution to the issues raised in grounds 1 and 2. First, clause 32 itself. Second, the State Immunity Act. Given my lord's pre-reading, I don't intend to trouble you by turning to those at this stage unless it would be helpful. I turn now to the substance of the appeal. Learned friend takes us to task, for he says structuring our submissions artificially, and says, finally, we engage with the issue which actually matters, i.e. the proper interpretation of clause 32, before then castigating us for having submissions that are wholly inadequate. If the issue which actually matters, using my learned friend's words, is the proper interpretation of clause 32, I hope the following 6 points may assist. First, the clause is concerned with disposal and arbitration, i.e. with adjudication and not execution. Second, this much is obvious from the language of the clause, the two key phrases, third sentence, the award will be final and binding upon the parties. Last sentence, both parties agree that the decision of the arbitral panel shall be final, binding, and wholly enforceable. Third, it follows that the words wholly enforceable adhere to the decision of the arbitral panel, i.e. its award of the 5th of January 2016, and its consequences, in the sense of it being brought within the shelter of Section 101, sub 2 of the Arbitration Act, through the application that was made by GD UK to commence the enforcement process. Means no more, no less than that. Fourth, this reading makes sense when considered through the lens of the natural and ordinary meaning of the word enforceable, which we submit means to give something legal effect, something able to be imposed so that it must be complied with, something recognized as enforceable by courts and tribunals around the world as res judicata between the parties. Fifth, the word wholly means that the parties agreed that the entire award or decision of the arbitral panel should be so treated, binding, final, wholly enforceable. And sixth, there is no language, no clarity, no express words that meet the threshold in Swiss or English law to enable the court to say Libya waived its immunity against execution. Nothing to support the contention it consented thereto. If this analysis is correct, if it is in our submission dispositive of the appeal in our favour. The grounds of appeal, your lordships have been good enough to consider already, and they're at Core Bundle 1, page 40, and I don't trouble you to turn to them. There are two parts to the analysis, which with your leave, I shall lay out over the remaining time that I have, which correspond, as you would hope, to the two grounds of appeal. The first ground is a general one of statutory interpretation. We say that the learned judge erred in holding that clear words are not required for a state to provide written consent to execution for the purposes of Section 13. The second ground is different. It is that the judge erred in holding that as a matter of construction of the relevant contract, Libya had provided written consent for the purposes of Section 13, when in fact the words used by the parties did not meet the required threshold under the SIA as interpreted under the governing Swiss law. As to the interaction, my lords, between the two grounds, we say that if Libya succeed on the generality of ground 1, then that makes it easier for it to succeed on the specificity in ground 2, but we still have to satisfy both. But even if the court is not persuaded on ground 1, nevertheless we could, and we say should, succeed on ground 2. Pausing there, my earlier friends seem to say in their skeleton argument that the first ground is artificial, it's a word that they use to describe it, and that the 2 points can be collapsed into the same question. See there, paragraph 6. But we suggest with the greatest of respect that the claimant thereby attempt to avoid engagement with the first ground, which is misconceived, we say, for 3 reasons. First, as a matter of principle, there can be no serious debate that in the United Kingdom, the State Immunity Act is a complete code and the sole source of state immunity. The Act sets the test for waivers of immunity, and it must follow, therefore, that the test for waivers as a threshold question is a question of statutory interpretation. Second, we note that our 2-stage approach was in fact that was adopted by the judge in his judgment. See his paragraph 12. Third, it's notable that the judge granted permission to appeal on both grounds, not just one of them, and we can see his reasoning in the supplementary bundle, tab 17, page 202, paragraph, page 25. But I leave that on the page.
Just to pick you up on one thing, I think, following from what my lord said earlier.
Yes.
The State Immunity Act just doesn't use the word waiver, does it?
No. It doesn't.
And what, as I understand it, the way it works is that there is a general statement of immunity, and then there's a series of exceptions.
Yes.
And just as Section 2 doesn't talk about waiver of adjudicative immunity, it talks about submission. Section 13 doesn't talk about waiver of immunity against execution, it talks about consent.
Yes. Which is why my lord picked me up on my expression of the first question. I understand. I'm sorry, I didn't mean to cut across you, my lord. Do forgive me.
No, I just thought perhaps ought to clarify that, because you said that you're looking at the exceptions by way of waiver to, and this is no concept of waiver in the State Immunity Act.
What I mean by that is, as I said, linguistic shorthand. I mean by that the consequence under the State Immunity Act of Section 12, Section 13, subsection 2, is that there cannot be enforcement against a state of the nature specified in sub 2A and B. That is derogated from under 3, which is where there has been express words, etc., used that connotes consent to, for example, here conceptually execution. I use waiver there as a shorthand because what the state would be doing is waiving its right to state immunity under sub 2 by giving consent under sub 3.
Is there a difference between written agreement in subsection 2.2 and written consent in 13.3?
Not if the agreement amounts to consent, and one is a consequence of the other. I wonder whether it's helpful if I just interpolate this point, that we use the language waiver in the way in which I just explained, picking it up from the case law, but I fully accept it amounts to the same thing, namely, it is the same as consent. The de facto position is immunity. It's only derogated from where there is consent to or immunity waived as to that right.
Yes, thank you.
Thank you very much indeed, my lord. I didn't want to cut across you a second time. Ground 1. I'm going to, if it's not too tedious, just give references in the skeleton arguments to where you find the arguments, but not take you to them unless you wish me to. So our skeleton starting at page 19, GDUK skeleton starting page 49, core bundles 2 and 3 respectively. On ground 1, our case is that key words, clear words are required to waive a right or consent to the loss of that right to immunity from execution under section 13.3. But let me make this plain in case there's any doubt about it. We have never argued that there is only one acceptable formulation for such wording. There is not. What we do say, however, is that the words used in the particular contract here were neither clear enough nor express enough to meet the statutory threshold. Put another way, the words did not amount to an express, unqualified articulation of a surrender of the state's immunity against execution, or putting it the other way around, as my lord's my favour, consenting to that execution. And we therefore say the approach of the court below was in error for 5 reasons. I'll identify each and then address each briefly in turn. First, the judge did not take into account the purpose and legislative context of the State Immunity Act, which sets a very high bar consent to execution or waiver of execution immunity. See his paragraph 5, R skeleton, page 20. Second, the judge adopted the wrong starting point of analysis by treating the contract as a standard transaction between two commercial counterparties. Here's paragraph 15, R skeleton, page 23. Third, the judge's approach to section 13 was inconsistent with the international treaty which the State Immunity Act was intended to implement. R page 24. Fourth, the judge confused the need for clear words or express words with the absence of the need for specific words. Here's paragraph 24, page 25. And fifth, the judge's analysis of section 13 failed to reflect principles of contractual interpretation as regards the waiver of valuable rights that formed the legislative background to the State Immunity Act. R skeleton, page 29. Can I take each of those in turn? First point, the purpose and context of the State Immunity Act. My first point is that in interpreting the State Immunity Act, it is necessary to have regard to its purpose. We anticipate this principle to be uncontroversial. If authority were needed for it, we find it in Benyon. I'm not going to trouble you to turn to it. I'll see whether my friend quabbles with it. I don't think he will. It's Authorities Bundle, tab 33, page 974, paragraph 11.1 for your note. But as I say, I'm not going to trouble you to turn to it at this stage. And although the State Immunity Act was enacted in part to codify the restrictive rule of state immunity in the UK, it did not entail that transactions with states ought to be treated in the same way as transactions between two commercial counterparties. To the contrary, states maintain a special status, are entitled to robust protections even when they choose to descend into the marketplace. There is consistent authority at the very highest level that highest degree of protection is to be accorded to immunity from execution. The numerous protections for states run, as my lords know very well, through the Act and its scheme. For example, the court is required to give a state immunity even if the state does not appear in the proceedings before it. There are two different types of immunity that states enjoy: adjudicative and enforcement. And section 13 makes clear that waiver of the first does not amount to waiver of the second. It is well established that the burden of proving the application of an exception to the State Immunity Act lies on the party opposing immunity. The proper approach to the Act was the subject of detailed analysis in the Supreme Court judgment in an earlier part of this case. Could I invite you, please, to come to Authorities Bundle, Divider 17, page 492. This is in the middle of the speech of Lord Lloyd-Jones. By way of introduction, I'm sure my lords are more than familiar with it. May I just say this? This was a case concerning the requirements for service on a state under section 12. There, much as it does here, we respectfully submit, GDUK sought to downplay the importance of state immunity so as to weaken the protections accorded to the state when it enters into a commercial transaction. The Supreme Court rejected this approach as a matter of principle. Lord Lloyd-Jones, giving the judgment of the majority, said as follows at paragraph 58, which is at the bottom of the page: consideration of international law and comity are in play here, and they support the wider reading of section 12.1. The SIA is primarily concerned with relations between sovereign states, and as a result, its provisions fall to be considered against the background of established principles of international law. He then quoted in paragraph 59 of the judgment from the judgment of the ICJ in the jurisdictional immunities of the state. And on the following page, page 493, he quotes this line: "Exceptions to the immunity of the state represent a departure from the principle of sovereign equality." Lord Lloyd-Jones then went on to explain that such considerations apply with all the greater force to situations where, as here, enforcement is sought. He said, referring to the ICJ judgment, "These observations apply to both immunity from a state's adjudicative jurisdiction and immunity from a state's enforcement jurisdiction. Indeed, the latter may give rise to even greater sensitivities in view of the fact that the power of the forum state may be enlisted to seize assets of the defendant state." May I weary the court by turning to the other bundle of authorities on this exact point, to the second bundle of
So
authorities.
what happened in this case, as I understand it, is that the question was what needed to be served on Libya.
Yes,
And this court had held, well, it all depends on the CPR. Reversing Lord Justice Mayles, who said, no, it all depends on Section 12.
yes,
And I think it was Miss Justice Tier who had authorised service by alternative means.
correct.
And I infer that that was on a without notice application.
Yes,
So service by the alternative means was not something to which Libya had consented.
correct.
The question here is, has Libya consented? So although Lord Lloyd-Jones was speaking of international principles and comity and all the rest of it, that was in the context where it could not be said that the state had consented to this particular means of bringing it within the jurisdiction.
Yes, my lord is of course quite right. It was why I wanted to point out, as I did, the short factual position that this appeal that we're looking at here was concerned with. I take the difference, and it's not a complete read across. It's not an answer to this appeal, and I don't pretend it is. But it is from the highest and most recent authority, indicative of the correct approach to be taken to issues of consent, accepting the difference conceptually between not having provided under the ex parte order and Mr. Justice Tier made, and the situation here. I accept that, but it still, we respectfully submit, is a helpful read across because it is so close to home, concerns this case, this state, and the approach taken by the other side being a mirror, hold up a mirror to that in this case. I hope it might be helpful to look at something, particularly in light of my lord's helpful intervention, that I was going to take you to now, which is in Authorities Bundle 2, tab 30. Which is the law of state immunity, with which my lords will be familiar, of course. And if we look at the last page in this extract before divider 31, you find that in Fox and Webb, this is said at the top of page 936, as it is. The authors observe, enforcement against state property constitutes a greater interference of the state's freedom to manage its own affairs than does the pronouncement of a judgment or order by a national court of another state. That as a principle, conceptually, is, we submit, in play in this appeal. It was in play in a different sense in the Supreme Court decision, accepting what my lord said about the different situation, but it is helpful as a matter of general principle from an authoritative source here. Turning, if I may, to the case law, there is a consistent trend amongst English court cases to the effect that clear words are needed for immunity to be waived, if I may use that word as they do in the authorities, or as my lords might prefer, to show that the state consented to the loss of immunity, consented to execution, call it what one will. And I'm going to show you, if I may, as briefly as I can, 3 cases. I do it well up on the clock, but I do it because I think it might be helpful just to remind you of how this matter has evolved in case law in recent times. The first case is Arab Bank and the International Tin Council, which is, if I can invite you to put away bundle 2 of the authorities, please, my lords, and take up again bundle 1. It's tab 5 of bundle 1 of authorities. And it's a decision of Mr. Justice Stain, as he then was. Can I just sketch for you or remind you of the position of what the case was concerned? It's not on all fours, the situation here. One case we'll come to is, but this is not, okay, I emphasize that. The bank had lent the International Tin Council a sum of £15 million, and the loan agreement contained a clause which provided, and I quote, "The credit facility shall be subject to the non-exclusive jurisdiction of the English courts." The Tin Council became insolvent shortly after the loan was made and started considering a restructuring which would have significantly disadvantaged the bank. Therefore, the bank sought a moreover injunction to prevent the Tin Council from removing the relevant funds from the UK. The question in that case was whether the clause I have mentioned created an immunity from suit only, as the ITC contended, or whether it created in addition a waiver of immunity from enforcement, such that the moreover relief could be granted against the ITC. Mr. Justice Stain rejected arguments that waivers of immunity were to be expansively interpreted, notwithstanding the shift in English law to a doctrine of restrictive immunity. To the contrary, he said, and I can take you please to page 136 in the bundle pagination. Waivers may be presumed, he said, they must be clearly established. Sorry, may I read it again? Waivers may not be presumed, they must be clearly established. And if the relevant clause is generally capable of more than one meaning, the narrower construction must prevail. Thus, one would expect to see an express waiver of immunity from execution, that for the intention of the parties, was a point made by Mr. Justice Stain, where he observed at the bottom of page 136, going over to the top of page 137, that one commonly finds in international loan agreements to which a state is a party express waivers of both immunity from suit and immunity from execution. Mr. Justice Stain went on to reject the argument of the bank that immunity from execution had been waived. Arab Bank was cited in the hearing before the learned judge in this case, but the judge didn't address this important authority in his judgment. My learned friend says in his skeleton, his paragraph 24.2, that the Arab Banking Corporation case did not concern section 13.3 of the State Immunity Act. Whilst he is correct to point that out, the International Tin Corporation was an international organisation, not a state, why I emphasise the difference right at the start of my address on this case. Such that section 13 did not apply directly, it is clear that Mr. Justice Stain considered the principles applicable to both to be the same. Indeed, learned friend, with the greatest respect to him, overlooks the fact that the judge referred on page 137 to section, the second paragraph on the page, first full paragraph on the page perhaps, to section 13.3, and there was no suggestion that the principles applicable to the interpretation of waivers should be any different for international organisations than for states. Indeed, as a matter of principle, we would respectfully submit that states are deserving of a higher protection than international organisations, So the principles in Arab Bank apply a fortiori to Libya rather than not at all, as my learned friend suggests. My learned friend also says that Arab Bank was preceded the cases of A and Republic of X and Sabah shipyard, but that too is irrelevant. 2 points. One, Arab Banking Corporation has never been overruled. And two, for reasons I will explain, it is in any event consistent with those later authorities, properly understood. Second of my 3 cases on this point is in the same bundle of authorities, please, tab 15. And it's the Avionics and the Republic of Nigeria case. Decision of Mr. Justice Males, who then was. And here I note that the facts of the case are very similar to the present case, and it deserves particular attention. The claimant brought proceedings in England to enforce an arbitration award against Nigeria. The claimant obtained a final charging order against premises in London owned by Nigeria, and Nigeria challenged such charging orders on state immunity grounds. The point at issue was the exception to execution under section 13(4), the commercial purposes exception, rather than the waiver exception under 13(3). On the facts, the property was held not to be in use for commercial purposes and so was immune. But the comments of Mr. Justice Nails at the conclusion of his judgment are important, we respectfully submit, and of wide significance. Could I invite you, please, to look at paragraph 51 in his judgment, which is the last paragraph on page 435. Mr. Justice Males emphatically rejected the suggestion that a commercial contract with a state is to be approached in the same way as a contract between 2 commercial entities. The courts must remain steadfast even if such distinction leads to unfairness. He explained, I would have thought that the interests of justice in this case would be best served if the defendant's state were to honour an arbitration award made against it, which has been upheld by and converted into a judgment of its own federal high court. However, the law of state immunity exists in international law and has been given effect in the 1978 Act in order to promote wider interests of justice than those of the parties in any individual case. For the reasons I have given, the Fleet Street property is immune from execution. The charging orders must therefore be set aside.
Why is that rejecting the idea that the contract should be interpreted differently?
He does earlier up in the judgment.
Does he?
But it's a recognition.
This was a case on the facts, wasn't it?
Yes, it was.
The question was, is this property in use for commercial purposes? And on the facts, it wasn't.
Correct. But the point that it addresses is that is captured in paragraph 51,
Yeah.
which is this, that whether, and there's an element of this in this case, from GD UK saying it's all very unfair, what are we meant to do? Whatever sympathies a court may have towards a commercial party which contracts with a state ought not to influence the approach of whether that state has consented to execution or waived its immunity. We take away that point from what Mr. Justice Mayers last says.
I thought they were looking at a consistent trend that clear words were needed to waive immunity.
Yes.
Does this deal with that?
This doesn't deal with it so closely. What it deals with is the fact that on the facts, as my lord said, as Lord Justice Lewison said, the court found that the commercial property exception did not obtain. In those circumstances, the protection was in place, and the property was immune. And the learned judge then goes on to deal with the importance of state immunity in international law, which is given effect in order to promote the wider interests and so forth. And if you allied that with the other authorities, you're left in the position that the court recognises, I'm sure my lord, as you nodding, sees the point, where the court recognises that if you have a state, it is entitled to the full suite of protections under section 1213 when one comes to issues of enforcement and execution. In order for that to be derogated from, requires express words, and all that Mr. Justice Mayles here is doing is, for our benefit, is underlining the importance of state immunity in international law and given effect to the 1978 Act to promote a wider interest than just those of the parties. It aligns with the other authority, which is, I'm going to turn to the third and the last case on this, if I may, which is Svenska, which we've already looked at. I'm not going to take you back to it in terms at this stage. You will remember that the case concerned a dispute between a Swedish oil company and the state of Lithuania. The Swedish company achieved an arbitral tribunal which it sought to have enforced in English courts, and Lithuania claimed immunity. And perhaps this is just the takeaway that one can note in this context. The language used in the contractual documentation provided the state had, the Court of Appeal concluded that even language which provided the state had irrevocably waived all rights to sovereign immunity was too imprecise to have the effect argued for by the claimant.
As to whether it was a submission to the jurisdiction.
Yes. So one has a building picture in our submission that there is an accretion of importance of rights that require protection for a state, which are different to the accretion of rights that a commercial party will have. Secondly, that where you have the protection of those rights, the most important of them is execution. It is expressed in terms as being a protected right within Section 13. When will it be derogated from? When, in writing and by express words, the state can be shown to have consented to that derogation and assented to execution. Short of that, we respectfully submit the language is inadequate authority, and if it's inadequate, it's a matter of generality, it's most certainly inadequate here, because what my learned friends can't do is point to any language that says, well, this is where they consent to execution. This is where they waive their privilege against execution. And we come back, therefore, to the point my Lord first put to me at the start of the submissions. And in our submission, that is, in one sense, the end of the matter. Now, can I turn to the second of the points on ground one? Much shorter, all these points, 2, 3, 4, and 5, all much shorter. The second point is that the learned judge took the wrong starting point for his analysis. Our skeleton paragraphs 18 to 21. Learned friend skeleton doesn't really address this point head on, but it's mentioned in his paragraph 13.3. We respectfully submit that if one looks at the judge's judgment, that he adopted the wrong starting point in his analysis of the contract. I know you've read it, so I'm just going to give you the reference to it, unless you would like me to look at it with you, and I see my Lord reaching for it now. It's Core Bundle tab 6, page 81, and it's his paragraph 15. The learned judge explained his approach at paragraph 15. It is necessary to start with the obvious point that from first to last, the contract was a commercial agreement between the parties. I conclude that a reasonable person, with all the relevant knowledge of the parties and applying the good faith principle, to a phrase which I shall return, I promise, would conclude that the intention of the parties was that each should be able to enforce its obligations against the other in accordance with the terms of their engagement. In short, we submit that to be consistent with the statutory scheme of the State Immunity Act, as interpreted in the judgments we have just cited, the judge ought to have started from the position that Libya was immune unless there were cogent reasons, cogent language, express words, clear words, call it what you will, to depart from that position. By treating the contract in the manner of any other commercial transaction, the court's judgment took a wrong turn at the outset of its journey from which it ultimately never recovered. Our third point.
I'm just slightly struggling with this. I mean, it's right to say that it's a commercial agreement, isn't it?
It's right to say it's a commercial agreement, of course, between a state and a commercial entity. And it is the special status of the state that is material in this context. Because if you have just a straightforward commercial contract between two parties with competing interpretations of what is meant or what the contract says and means, that's one thing. And it sets you off down a path of reasoning where you weigh competing interpretations. But actually, when you're dealing with a state, what you should be doing is starting with the immunity under the State Immunity Act and ask, as my lord put it earlier on, where is there a consent to depart from the right against execution, for example? If the answer to that is no, the burden of proving whereof lies on the party asserting it doesn't exist. The answer to that is no, then the state wins. It's not a question of weighing competing analyses in our respectful submission. So whilst my lord is entirely right, if I may say so, of course, that this was a commercial contract, that's not actually the question. The question is the status of the parties to that commercial contract and how that informs an approach to its terms.
Solely on the question of enforcement.
Yes, in this instance, yes.
I mean, if it was some other question of contractual interpretation, you would interpret the contract as a commercial contract.
Well, supposing it was payment terms
Yes.
or something such as that.
Yes.
Yes, of course. I can't imagine for a moment that anything in the State Immunity Act would come to Libya's aid if it failed to make a payment, for example. But as my lord says, solely in relation to, I would respectfully expand it a little, enforcement.
Adjudicative immunity and...
Exactly so, yeah.
What the task that the judge is addressing is whether or not the clause constitutes a consent to execution.
Yes.
That only arises because Libya is a state with prima facie immunity.
Yes.
So plainly he has that clearly in mind, that that's the exercise that he's doing. And what he is saying in that context is that he takes into account that it is a commercial agreement between one party and a state. He's not ignoring the fact that Libya is a state, because that is the nature of the exercise. I'm not quite sure what he's done wrong.
Okay. Well, forgive me being so trenchant in my criticisms of a senior and respected judge. You understand, I don't mean to be offensive.
It's the argument we're interested in.
Yeah, what he's got so completely wrong is this, that he looks at it through the lens of this being a straightforward commercial arrangement between two parties. He nods towards the fact that one party is a state, but he doesn't follow that through to say, and therefore, whilst it is a commercial arrangement for the purposes of immunity or waiver, if I can use that word still, or consent, if preferred, I have to look at it through the lens of the State Immunity Act. And if I do that, then the first question is does Libya have, my words, prima facie immunity? Yes. In what circumstances will that be derogated from? The second question. Answer, where there is express consent to execution. Narrowing it down to the facts of this case.
Sorry, can I just clarify?
Yes.
It's common ground, indeed, the contract provides that it is governed by Swiss law.
Yes.
So in applying Swiss principles of interpretation, why should the judge looking through the lens of an English Act of Parliament?
Because one starts with, and this is where the two grounds of appeal, we didn't settle them, but where they seem to us to intersect. You start with, if you like, but we're taking it in this order because the ground one is ground one, so otherwise might have started the other way around, but never mind. You start with, what is the Swiss law, which we gripe about, as you know,
Yes.
later in this appeal, the judge's approach. Having then established what the position is in Swiss law as regards the sufficiency of the language, if sufficient, it then has by an English court to be looked at, because it's English court and English proceedings, through the State Immunity Act lens. So English State Immunity Act law comes in once you have established what the Swiss law position substantively is.
Yes. What does this contract mean in Swiss law?
Yes. So you're not asking me? Or,
That's the question.
Yes,
The
well,
first
certainly
question. What does this mean as a matter of Swiss law?
which is where I started.
Yes, and if it means X, then that amounts to consent. If it doesn't mean X, then it doesn't.
Yes, I mean, yes, absolutely. So if in Swiss law, the language was, may I use the word express, because it appears in the Swiss jurisprudence and academic authorities you've seen, both parties rely on. If it's express, then that's what the Swiss law means. The language is express. Then the court says to itself, with that founding principle in mind, I look at the State Immunity Act to see whether or not under section 101 sub 2, looking ahead down the Arbitration Act lens, does this allow for, what does this allow for? Yes, enforcement, yes, execution on this hypothesis. Therefore, I say to myself, did Libya consent to execution when it entered into this contract? Answer, yes. Does that amount to derogation from the State Immunity Act exception? Yes.
Yeah.
That's how it works. Can I move on to the ESCI point, which is we submit that there was a failure, it's our third of 5 points on ground one, to interpret the State Immunity Act consistently with the international treaty it served. The ESCI, or European Convention on State Immunity, is the origin of the power and vesting in the courts in this country under the 1978 Act. There is no dispute that one of the main reasons for the State Immunity Act being enacted in 1972 was to enable the UK to ratify the convention. And the UK ratified the convention on the same day that the Act came into force. If authorities needed that proposition, it's in the Libyan Supreme Court judgment at paragraph 45, not going to trouble you to turn to it. And there is a general principle of interpretation applicable to domestic implementing legislation of international treaties. And despite it being well established that the Act was intended to implement the convention, no friend denies at paragraph 27.5 of the skeleton that the convention can be used reliably, his word, whatever that is supposed to mean, as an interpretive aid, because the language of section 13.3 is different from the convention, to which we say these points. One, there's no suggestion in either the wording of section 13.3 or in Hansard that Parliament is intended to depart from the convention. Neither side has suggested that. The word expressly, which appears in Article 23, which I've failed to show you so far, and I'll take you to it in a moment, was not transposed across, but nonetheless as an international instrument which binds the UK and which the UK intended to implement, we say that a harmonious reading is appropriate, nay, essential here. It is necessary to interpret the Act, we say, in accordance with the wording of the Convention, which I will just briefly show you. I don't know whether you've had a chance to look at this already. You'll see the point. I see my lord is nodding. But may I just do it very briefly, please? It's Authorities Bundle tab 39. So the other bundle of authorities, please. And if I could invite you, please, within the tab to turn to page 1015, Article 23. You'll see it says, no measures of execution or preventative measures against the property of a contracting state may be taken in the territory of another contracting state except where and to the extent that the state has expressly consented thereto in writing in any particular case.
I'm not quite sure I understand how that helps terribly much, because as I asked you earlier, once you've interpreted the words of the contract and understood what they mean, whatever they mean is express, because that's what the words mean, that's the way the parties have expressed themselves.
It merely assists, and it's not a big point, and I've nearly done it, and I'll move on. But it merely assists in this sense that if one accepts the proposition that one has to view what the State Immunity Act means through the lens of its subordinate or superior convention, and we submit that is the law, one does. If we look at Article 23 and see where the convention sets the bar for specificity, using a different word, when one is dealing with the issue of execution, it uses the word expressly, which emphasizes the importance of precision and clarity and lack of equivocation and so forth. If you are asking the question that my Lord put to me right at the start of, isn't this all about consent? So if you're asking, has Libya consented to execution under this contract, the extent to which this helps is for my Lord to decide, not me. We would submit you derive some assistance from looking at the convention and its choice of language about it being expressed. And so, well, I leave it there.
That depends, doesn't it, whether the word expressly, before consented, adds anything to the autonomous meaning of the clause.
Yes.
In the convention, is there any learning on that autonomous meaning?
Yes, I mean, I don't freight the point with any greater weight than I've given it already, and I accept what my Lord says. Perhaps I might just leave it there. If it doesn't appeal, it's certainly not at the centre of our
There's
case.
an analysis of this in the High Court of Australia decision in ISL in Spain, which this court considered and followed these very recent
Yes,
expressments in that context.
yes, and I shall be coming to the Kingdom of Spain case in due course. But I'm going to leave the point there, if I may, and move on to the more conventional grounds of the fourth point, which is confusion in the judgment between special words and clear words. Our skeleton starting at paragraph 28. There is, in our submission, confusion of terminology in the judgment, which contributed to the judge's erroneous approach to ground 1. Specifically, he appears to have taken the phrase special or particular words to mean that no express wording was needed, but to do so was, with respect to him, a mistake. We agree, and have agreed already, that no specific words are needed to reflect a waiver under section 13.3, but it does not follow from that the words used need not be clear, indeed, to the contrary. You will have read already, paragraph 9 of the judgment of the learned judge. Last sentence. No special or particular words are required in order to satisfy the written consent requirement of section 13.3. I'm turning over the page to the next page, page 80, paragraph 12. At the bottom of the paragraph, he said it was common ground that no special words were needed. But in holding that no particular form of words is required to satisfy section 13.3, the judge placed much emphasis on the judgment of Mr. Justice Saville, as he then was, in A versus the Republic of X, which can be found, and I'd better invite you to turn to this, please, in Authorities Bundle 1, tab 6. It's an authority which the learned judge relied on, as did the learned friends. This was a case, my lords, in which the company sued the state for failure to settle a debt arising from a commodities contracts. Those contracts were governed by English law and contained a waiver in very clear terms, which one finds on page 141, left-hand column, clause number 6. The Ministry of Finance hereby waives whatever defence it may have of sovereign immunity for itself or its property, present or subsequently acquired. It could not have been clearer. The contractual wording in the Republic of X case specifically referred to waiver, sovereign immunity, and property, all of which are clear signs of to what it is consenting or over what it is giving a waiver. None of that language appears, as you know, in the contract in our case. Now, we respectfully submit that learned friends' reliance upon this authority, their paragraph 22, is misplaced, if I may say so with respect. When read properly, it is not authority for any broad proposition to the effect that a contract between a sovereign and a commercial counterparty is to be approached in exactly the same manner as a contract between two commercial parties. First, the decision in the Republic of X related to the wording of a particular contractual clause governed by English law. There was no need to consider the prior question of whether clear wording was needed under section 13.3 because the clause was abundantly clear. If one turns to page 142 in the authority bundle, left-hand column, penultimate paragraph, the learned judge says, "I'm not persuaded by any of these arguments. It seems to me that, read in the context of what was undoubtedly a commercial bargain between the parties, the intent and purpose of the clause is quite clear, namely to put the state on the same footing as a private individual, so that neither in respect to the state nor its property would any question of sovereign immunity arise in connection with the state's obligations to the plaintiff under the agreement." And on the same page, at the top of the right-hand column, the very first few half dozen lines on the page, the learned judge continued, "The present case is concerned with an ordinary commercial transaction, and I can see no good reason why the clause in question," note those words please, "should not be construed in like manner to the rest of the contract in accordance with the ordinary principles of construction for commercial contracts, by looking at the bargain as a whole or in its context, By reference to by the judge to clause in question, it makes perfectly clear that Mr. Justice Saville was speaking only with respect to the contractual clause then in issue. And when the judge said ordinary principles of construction, those did not lay down a general rule for the purpose of section 13.3 as a whole. They were simply the principles applicable to a particular English contract and without wider relevance. And the position in this case is therefore distinguishable.
But what the judge was interpreting in this case, as I understand it, were clauses 6 and 7 of the agreement. So clause 6 was what you call waiver, and clause 7 was the choice of law clause.
Yes.
It was argued by Mr. Jacobs that because this was a state, they should be given a restrictive interpretation, which is consistent with what you submitted 20 minutes ago. And Mr. Justice Saville says, no, those clauses, i.e. those which apparently waive immunity, should be construed in the same way as any other clause in the contract, i.e. in accordance with normal contractual interpretation. And that does, if I may say so, seem to be against your submission that when it comes to looking at clause 32 of this agreement that we are concerned with, the state should be put in a different position because of its state immunity.
My lord, it certainly would be against us if that were the end of the matter. But happily for us, it's not. Because in our submission, that one cannot divorce the finding from the fact. And if one looks at the clause, as I read it out in full and emphasised it, clause 6,
Yes.
as my lord highlights, it could not possibly be
Well,
clearer.
that point I understand.
I'm sure, of course you do, forgive me, which is why I just add that into my lord's synopsis of why this might be a difficulty for us. And so, whatever difficulty there may be latent within the case, it fades to naught when one considers the circumstances of the decision.
Right.
But we know that Lord Saville in the Pinochet case said that it didn't dissent from the proposition that waiver of states by states of immunities must be express or at least unequivocal.
Yes, exactly so. I was going to show you a passage from the speech of Lord Mance, but my lord's way ahead of me and from a different viewpoint, so I'm very grateful to you. And of course, one can, even for an advocate of Mr. Jacobs standing, it's an ambitious submission to say that he could get round clause 6 on the facts of that case. I mean, his language couldn't have been clearer in contrast to what we have in clause 32 in our contract. The other point I would just make about X is that if one turns to Svenska, which is back at tab 10 in the same bundle, please. Decision of a powerful constitution of this court, as you know, and we've looked at it twice now already. At page 237, one has paragraphs 127 and 128, which a long passage, I shan't read it out. Could I invite you, please, just to cast your eye down 127 and 128 on page 237? You see how the learned judges there dealt with the Republic of X. Sorry, thank you. So you can see.
The thing about Svenska though is that was a case where what was being looked at this point on an obiter basis was a general waiver of sovereign immunity, a submission to this jurisdiction.
Yes.
And the court said it's too precise to be a submission to the jurisdiction of the courts of England and Wales.
Yes.
And that's particularly so, he said, because you've submitted to arbitration. So if you're submitting to arbitration, how can you construe that as a submission to England and Wales? So I'm not sure how far it helps you with whether or not wording is consent to execution.
Well, I quite understand that. We're into quite new ground in aspects of this appeal. And so both sides have searched far and wide for what might tell upon the answer. And what we take from this passage is this, that in upholding the decision of Mrs. Justice Gloucester on the grounds of A versus Republic of X is distinguishable, they talk about containing an express choice of English law and an express submission to the jurisdiction of English courts, exactly as my lord has just pointed out to me. And the repetition of express by the Court of Appeal was clearly intentional. By contrast, as I noted earlier, to the relevant clause in Svenska was deemed too imprecise to constitute a waiver. So it's merely more of the general theme of the need for express choice of words when you're expressly, as a state, waiving your protection against execution under the State Immunity Act.
Well, the question was whether a general waiver amounted to a submission. Yes.
Yes, I take the point entirely, and I'm stuck with it, as it were. But the authority Svenska is still useful as casting a light on how far the judgment in Republic of X really takes GD UK in this appeal. That's because of the second thing that we say, and the last point on this part of our submissions, is that this authority, A in the Republic of X, is not authority for the wider proposition for which it's invoked by GD UK and was endorsed by the learned judge, to the effect that all contractual provisions set to fall within section 13.3 must be construed in accordance with the ordinary principles of construction for commercial contracts, as see his judgment, paragraph 8. The reference to ordinary principles of construction, I realise I'm here trusting on ground we've already covered to an extent, must have referred to English law principles, because Republic of X, the contract was governed by English law. Here, non-English law governing the contract must be interpreted pursuant to the relevant principles of construction. Move on to the fifth and last point on ground one. I anticipate finishing System Learning Friend before 1:45, just so he's aware of that. Hope I don't now, having raised hopes, dash them. The fifth point, the court's approach was inconsistent with pre-existing common law position on waivers of valuable rights. This is my fifth and final point on ground one. In that we admit the court's approach was inconsistent with the law as it stood under the pre-existing common law provisions that predated the Act, and that it is very difficult to waive a valuable right. There appears to be no dispute between the parties, as one would expect, that there is a principle of legislative construction to the effect that the pre-existing common law is to be taken into account when interpreting a statute, especially where there is no indication that the relevant word or provision was intended to effect a change to the law. Authorities needed for that, I can give it to you and look at now. It's Benyon, Authorities Bundle, tab 34, page 977 to 978. It also appears to be common ground that there was, prior to the enactment of the 1978 Act, House of Lords authority that the clear and express words are needed to waive a valuable right. The authority for that, which I don't trouble you with at this stage, is Modern Engineering and Gilbert Ash, Authorities tab 3, page 36.
That's a principle of interpretation of English contracts, isn't it?
It is. Yes, it is.
But this Act is plainly designed to cover, amongst other things, contracts wherever in the world they're made. So why should the principle of English contractual interpretation affect the construction of this Act of Parliament if there were an equivalent Swiss principle of contractual interpretation? I can see its relevance, but I don't at the moment understand how the Gilbert Ash line of cases, which is very well known,
Yes.
can affect this point.
Merely to this extent, and it's rather like the third point, is not at the centre of our complaint. Merely this, that there is a theme that comes from the Gilbert Ash line of cases, of which it is the real source, that where one is dealing with the waiver of valuable rights generically, and I accept this is in the context of English domestic contract law, that precision and expression and exactitude is required. And we submit that where one is dealing with the self-same concept in a statute that comes as the State Immunity Act does, to codify the law of state immunity, that it would be very surprising if that was read in any way which is less strict than had been its common law history. Don't put it any higher than that.
The Act wasn't just a codification, was it?
No, it wasn't just, no, but it now comprises the entire law on state immunity after its passing.
For example, the provisions that regard submission to the jurisdiction were more liberal, weren't they, than was the pre-existing law?
Yes, as I say, I accept it wasn't only a codification of the pre-existing position, but it now constitutes the entire law. And all I'm saying is that applying general rules of construction, one may, in certain circumstances, look back to the common law history that precedes a statutory provision and see how that authority illuminates how the statutory code in that respect should be considered. And here one is only not looking at the entire Act, one is looking at just the provisions with which we are dealing. Can I turn to the second ground of appeal, please, which will be much shorter than was our submissions on the first. Ground 2 of our appeal relates to the construction of clause 32 of the contract, as my lords know. Our skeleton page 31, GDUK skeleton page 57. It is common ground that the construction of this contract is a matter of Swiss law, and we make 4 points. First, the judge, with respect to him, fell into material error in his consideration of the relevant Swiss law principles, and as a result failed to consider key authorities which support Libya's position that the words used were insufficiently clear to constitute a waiver. See the bottom of our page 31 in our skeleton going over to the following page. Second, rather than seeking to decide between 2 alternative constructions of the contract, the only real question was whether the language is sufficient in Swiss law to effect a waiver. Third, the learned judge paid insufficient attention to the wider context of the contract and to the commonly accepted forms of sovereign waiver clauses, which are very different to the language of clause 32. And fourth, and I hope I don't need to dwell too long on this, the learned judge applied his own, if I may say so, homespun approach to the Swiss notion of good faith, a theme to which he himself warmed from paragraph 13 through 15 through 17 to 22, as a means of supporting his own conclusions, which were inherently in themselves erroneous, compounded by this notion of good faith as he used it. So first point, the judge's mistakes as to the relevant Swiss law principles. There is, as you know, no dispute that the contract is governed by Swiss law, and therefore its meaning is to be interpreted pursuant to Swiss law principles. GDUK seek, it seems to us in paragraph 34.2 of their skeleton, to try to restrict this court's ability to reconsider the findings as to Swiss law because they say they were questions of fact. That submission, if it is what is really meant, is not well founded for two reasons. First, the findings, such as they were, of the judge on foreign law were not made on the basis of any expert examination or live evidence. They were made solely on the papers. And this court doesn't need the likes of me to stand here and tell you how the Court of Appeal will look, where it is equally as well equipped as the court at first instance at written material afresh. It was common ground in the court below between the parties that this was a dispute in which the rules of foreign law, or foreign evidence, could be given by English solicitors via witness statements. No expert witnesses of foreign law, no cross-examination of English solicitors on the foreign law principles. And in the premises, we would suggest this court is just as well placed as the trial judge to assess those materials. The Swiss law materials in issue in this appeal were agreed by both sides to form part of the appeal bundle. GDUK cannot seriously contend, having agreed the materials should be in the bundle, is not able to the court to consider them. Second, it is well established that the Court of Appeal is entitled to depart from a finding of fact where that is demonstrably wrong or based on material omission. And unfortunately, and with the greatest of respect to the learned judge, wrong is what the position is here. The judge made an unfortunate and basic error concerning what was and what was not agreed about the Swiss law between the parties. Could I invite you, please, in the judgment to paragraph 11. The learned judge states there that his first task is to construe the words used by the parties. Then the judge endorses a purported summary of the relevant Swiss law principles from the fifth witness statement of Mr. Brocklesby, who was GDUK's solicitor. And the judge's treatment of the relevant principles in Swiss law was regretfully wrong for two related reasons. First, the learned judge made a clear error in his assessment of what was and was not common ground. The judgment provides at paragraph 11, as you know, that Libya accepts that Mr. Brocklesby's summary reflects accurately the current status of the law in Switzerland. See paragraph 40 of the third statement of Libya's solicitor, Ms. Zacaroli. But if we look at Ms. Zacaroli's witness statements, she accepts no such thing. Could I invite you, please, to the supplementary bundle, tab 14, and bundle page 93.
Sorry, which page?
93, please. Thank you very much. At paragraph 40, you will see that Ms. Zacaroli says, the legal authorities contained in Annex A of Brocklesby 5 and in NB 5 are decisions of the Swiss Supreme Court and leading textbooks on contract interpretation and reflect the current status of the law in Switzerland. And so far, so good. And that's what the judge had in mind when he was giving his judgment. But we turn the page to page 95 and look at paragraph 41. She says, the correct interpretation in light of the above Swiss legal principles is a matter for submission. But I note here that the position set out in Brocklesby 5 is not agreed by Libya. So it can be seen that the learned judge made a clear mistake by misreading Ms. Carter's witness statement.
Well, she said the matter was for submission.
Yes.
What submissions did the judge have on the point?
Can I come back to that in just a moment? The consequences of it may be useful. What was not agreed was the characterization of the textbooks and Swiss Supreme Court decisions that are before the judge. My learned friends now seek to say in their skeleton at paragraph 34 that Libya's skeleton in the court below contains some principles which were agreed to be common ground. At paragraph 15, but that is not in our submission a fair or accurate summary. Libya's skeleton below referred to certain parts of Mr. Brocklesby's witness statements as being accepted, and this may be the closest answer to my Lord's question, but at no point did Libya accept that the summary quoted by the judge represents a complete or full statement of the relevant principles. So the point that learned friends takes them actually nowhere. And learned friends' contentions about Mr. Brocklesby's summary being common ground should not bear any weight. But second, and following on from the first error, the summary of Swiss law principles at judgment, paragraph 11, focused only on generic statements of contractual interpretation. And that's because the learned judge didn't address the Swiss authorities concerning the interpretation of contracts in which a waiver of state immunity is alleged, which is the key issue in the present case. And the irony here, as you may have picked up already, is that the material that we now rely upon is material that was not put in by our side, but put in by GD UK and relied upon by them. Two sources, as you will see: one authority of the Swiss Supreme Court, its apex court, one authoritative piece of academia. Had the judge approached properly the Swiss authorities in evidence, as to which there was common ground, these reflect the Swiss law, he would have considered and discussed the judgment of, as I say, the apex court in Switzerland, the Swiss Supreme Court, in Moscow Center for Automated Air Traffic Control, which is in the supplementary bundle, which I think you're still presently in, kindly, tab 18. I invite you to turn to that, please. In that case, the Moscow Center, which is a state entity of the Russian Federation, opposed an enforcement action taken by the court for debt enforcement against certain property in Switzerland. If I can invite you please to turn to page 212. And look at paragraph 5.3. The Swiss Supreme Court considered whether the Russian Federation had waived its sovereign immunity pursuant to a memorandum of understanding, of which provided, I'll read these words: accordingly, the government of the Russian Federation expressly recognizes the private and commercial nature of this memorandum of understanding and expressly and unreservedly waives any immunity from jurisdiction and or execution of which it may be the beneficiary. Crucially, and if my lords could here come at 5.3.1 on the same page, 212, the Swiss Supreme Court held the waiver by a state of its immunity from execution is possible in any case if it is express, which is the case in point. The Swiss Supreme Court also quoted and seems to have approved the Swiss court below, the decision of which it upheld, saying, in the present case, the waiver clause was sufficiently clear and explicit to allow the seizure of all the assets, whether they were used for the gestionis or imperii activities. The court confirmed this finding 533 on the same page by holding, I could invite you please to turn over to the last page, the penultimate paragraph on the page. That will be tantamount to depriving the waiver clause of all scope. Under the terms of the waiver, the Russian Federation has expressly...
Sorry, I've lost the place. Where are
page
you?
214.
214, yes.
The last few lines of paragraph 533 as it is.
Yes.
Picking up with the words, Russian Federation has expressly and without reservation renounced all immunities from jurisdiction and or execution.
Yes.
Combination of these expressions desire to give the waiver clause the widest possible scope. Consequently, it can only refer to property assigned to a jure imperii activity. And then 5.4, just like the Russian Federation, the appellant, which claims to exercise a prerogative of that state's sovereignty, cannot evade the enforcement by invoking immunity which the beneficiary has expressly waived.
Am I right in thinking from paragraph 5.2.1 on page 211
Yes.
that the contract was governed by the law of Luxembourg?
Yes.
So how can the Swiss court have been applying Swiss principles of contractual interpretation to a contract governed by the law of Luxembourg?
Well, the answer to that question is beyond me, except to say that at no point in the judgment do they ever indicate that there is any difference between the position in Swiss law and the position in Luxembourg law, and nor is there any suggestion in subsequent or commentary on that authority to that effect. I understand exactly my lord's point. I was going to make the point myself that is a point that is taken by my learned friends concerning the fact this is a case about Luxembourg law. But I wonder whether my lords might be helped by looking at the second source of authority on this point. Because in Mr. Brocklesby's 8th witness statement, immediately before citing the Moscow Centre case as evidence of Swiss law, which is, if I may say so, worth noting, pretty ironic really, that we should now be trying to justify it when they relied upon it. GD UK also referred to an article by Professor Dr. Kostkovitz, forgive me if I'm not pronouncing the name correctly, who is co-director of the Institute for Private International Law and Civil Procedure at the University of Bern. They endorsed that article as accurately summarising Swiss contract law. Could I take you to it, please? It's supplementary bundle tab 21.
Is that the article that the court in the case you just showed us was relying upon for the proposition that the waiver must be expressed?
Yes.
It's the same article.
It is. May I just check whether it's the same author? Can I just check? We think it's the same article, yes. Thank you very much. Can I just show you, please, on page 239 in the professor's article, waiver of immunity, Roman 3. Any state may waive the immunity to which it is entitled vis-a-vis the foreign state. The waiver of immunity may be either express or implied, but must clearly express the state's intention to do so. Bearing in mind the authority comes from such a source and is cited by the Swiss Supreme Court, as my lord helpfully pointed out, and I'm grateful. We respectfully submit that this being the best evidence that was relied upon by GD UK before the judge, it's good enough for us to rely upon it now in this court.
So it can be implied.
It can be implied, yes, but must clearly express the state's intention to do so. I'm not quite sure how that would necessarily work alongside the implication and expression, but I can probably construct a scenario. but it is the need for express or implied, yes, but expressly, clearly expressed, which is the narrowness of our complaint here, that wasn't clearly expressed at all.
I just understand, because I have to make, I find it a little bit difficult to work out. Let's imagine that Swiss law was such that even an express consent to execution wasn't enough for to permit execution against a state in Switzerland. So whatever was said by way of an express consent to execution wasn't enough there. Well, that wouldn't matter, would it? Because what we're looking at is the Sovereign Immunity Act in this jurisdiction.
Well, we would respectfully submit that it might be addressed in a slightly different way. May I try? That if the substantive position under the contract governing law, which is Swiss law, is that this is under Swiss law not good enough, the expression that you just put to me in your hypothesis, when the English court then comes to consider whether or not there has been waiver, if I can use that, or consent, preferred, under the State Immunity Act, it should start with the position in Swiss law. And if the position in Swiss law is not good enough, that's the end of the matter.
Well, that would mean that the question of whether there was a waiver of state immunity for the purpose of execution would be a matter of Swiss law in the first instance.
Well, not in the first instance, yes. So in the first instance, it would be. So you have a contract. The contract contains a clause that has a phrase in such as my lord just put to me, express waiver. Swiss law interpretation agreed between the parties, or found by the judge, is the language is not good enough under Swiss law. First stage. Second stage, English court to be considering whether or not, as a matter of Swiss law, the clause is sufficient for the purposes of waiving immunity against execution. Answer no.
But what if there is the clearest possible express consent to execution, but it is in a contract governed by a law of a country which doesn't permit execution against states in any circumstances? Why would it matter?
It would
not executing in that state.
no. It would matter, wouldn't it? For this reason, that it would be the end of the matter. It's for the parties to decide the jurisdiction, which is the applicable law for the purposes of the contract in question. If they choose a country, ex-stan, which has no concept of execution against a state, that's their lookout.
But that country may well recognise that there would be execution committed in other states. The fact that Switzerland doesn't, or Ruritania doesn't permit execution against states, doesn't mean that Ruritania wouldn't recognise that other states might permit action against states, execution against states.
Yeah, I quite understand that my lord is absolutely right to press me and test my hypothesis by ever increasing the extreme examples. But when we come back to this case here, none of that pertains, because we have something much more comfortable or familiar in that we have a contract under Swiss law, recognised in sophisticated jurisdiction, as to which you've seen some authority that was before the judge, and will form your own view on that. We say it has the consequence of meaning under Swiss law, the language used in clause 32 was not good enough, but nowhere close. And therefore, when the judge comes to consider whether or not, for the purposes of the State Immunity Act, there has been consent to execution, that the judge looks to the Swiss law on that and gets the answer no. And if there hasn't been, then that's the end of the matter under the State Immunity Act, section 13. because the search must be for something that is express or clear or unequivocal or all three. And so whilst one can go on a tour to Mauritania and other countries and postulate theses of lack of what we might call comity or lack of coherence between their legal system and ours, that happily doesn't trouble us in this case.
Doesn't that beg the question? If there is a Swiss law requirement that the waiver must be clearly expressed according to the article, but that is not a part of English law in terms of section 13, then what's the answer then? You are then relying on Swiss law, aren't you, to interpret the English statute?
Well, you're relying upon Swiss law to set the threshold, and then to that threshold you apply the statute. And so that if the Swiss law was sufficient, supposing the flip it on its head, if the Swiss law was to the effect that wholly enforceable connotes the conclusion is that the language is, sorry, start this rather rambling sentence again, start again. If the Swiss law was to the effect that wholly enforceable means you, Libya, contracted in Swiss law under this contract with GD UK to accept execution following an award in an arbitral tribunal, and that then comes to England, who is being litigated here, to be determined, then it is game over against us, because the court would look at section 13 and say, in this particular case, has the bar been crossed or not? Answer, yes, it has. Equally, the opposite pertains, and if as a matter of Swiss law, in this contract, the language is not good enough, then that also is an answer to the question.
Aren't we in danger of mixing up Swiss principles of contractual interpretation and the substantive requirements of Swiss law for enforcement against states? Now,
Yes.
suppose Swiss law said, no judgment shall be enforced against a state unless the contract uses the word waiver. And the contract doesn't. It says we consent to enforcement, but it doesn't use the word waiver. If you brought that contract to England, would not the English court be entitled to say, well, it may not use the word waiver, which is the requirement of Swiss substantive law, but it does use the word consent, which is the requirement of English law, therefore it has consented to enforcement.
Yes, I hope I said earlier, certainly I intended to, that it's a question of substantive law and then procedural law. So the substantive law of this contract is Switzerland, exactly as my lord said. And so if we had that situation, if the evidence had been clear before the judge as to what the Swiss law position was, and he came to a view on that, which was to the effect that you have just posited, then I completely agree with what you say. Completely agree. And the consequence then will be for the English court to take the Swiss substantive position in substantive Swiss law and apply to it the State Immunity Act.
Yeah. Can I ask a slightly different question about this article? It's not clear to me whether Professor Koshkovich is talking about substantive law or Swiss principles of contract interpretation. Now, I say that partly because if you turn over the page to what is said about enforcement proceedings on page 241,
Yes.
the question, despite waiver of immunity in discovery proceedings, which is what the article has just been talking about, the question whether a state waive its immunity from enforcement must be answered separately. It can be either express or implied, as in the discovery proceedings, and it goes on to say towards the end, when looking at implied waiver, it goes on to say the waiver can be seen in passive behaviour on the part of the state if the state does not defend itself against the enforcement measure in a specific case. It indicates it does not wish to assert the defence of immunity. Now, that sentence looks to me very like Swiss substantive law, not anything to do with the principles of contractual interpretation, because what it's saying is your silence in the face of an enforcement proceeding indicates consent. Well, that's got nothing to do with the contract.
I agree. But if one goes back to the start of this article on page 238,
Yeah.
one sees that the long title to it is Arbitration Clauses and Their Significance for the Waiver of Immunity as well as for the Requirement of an Internal
I
Relationship.
understand, but is the article talking about how you interpret them? That's my question. Because bits of it don't, because they've got anything to do with interpretation.
Frankly, may I just talk to Mr. Turner a moment? I'm grateful to Mr. Turner. He emphasised the point I made to you before, that of course this is material upon which they relied.
Well, no, but you told us that we're free to look at it again.
Yes, I agree, you are. They say you aren't, but we say you are. That the meaning of the contract is a matter of Swiss law.
Yes.
And the threshold to be met is the English law threshold. As I say, substantive and then on.
Yeah.
The Moscow Centre case was dealing with contractual interpretation.
Right.
Can I move on to the second point on this ground, which is the context to Clause 32 and commonly accepted waiver language. Our second point on ground 2 is that the judge failed to consider the types of language which are commonly used to waive immunity. As a matter of Swiss law, it is common ground that the surrounding circumstances at the time of the conclusion of the contract are always to be taken into account. And if you need a reference for that, it's Supplementary Bundle, tab 1, page 9, paragraph 15.3. The formulations of language which are accepted to effect waiver of immunity by contract are no great secret or mystery. To the contrary, they're well known, widely available, and it must be assumed would have been accessible as a matter of public knowledge to Libya as a state, and all the more so to a party as experienced in sovereign matters as GD UK would have been. And in circumstances where the type of clause in question was commonplace, it is relevant to consider the boilerplate language which would have been available and known to both parties, and in particular GD UK at the time of contracting. And there is extensive guidance available as to what the language in this regard might be in leading textbooks as well as via reported cases addressing contractual waiver. May I show you a couple of examples of what is typical? Can I please turn to Authorities Bundle 2. And tab 36. Which is Williams and Kent Commercial Enforcement. And come to page 985. And invite my lords to look at footnote 3 to paragraph 1.112, where an example of a typical clause is given. The state irrevocably waives all immunity to which it may or be or become entitled in relation to this agreement, including immunity from jurisdiction, enforcement of pre-judgment proceedings, and all other legal proceedings and relief, both in respect of itself and its assets, and consents to such proceedings and relief. If we then come back in the bundle to tab 32, have an article which I think is helpful on this. Waiver of state immunity and enforcement of arbitral awards, as you see, is the title on page 939. And this is in the Asian Journal of International Law, where the author provides what he describes as a comprehensive waiver of immunity. And you can see immediately when I show you it that the clause is lengthy and detailed, an example of the type of careful consideration and detailed drafting which is considered appropriate for waivers of execution immunity. And can I take you to page 972, which is the last page in this divider. And invite you please just to cast your eye down the long indented paragraph, noting in the second paragraph, State X consents to execution against any current or future property or other assets of it or any other's organs.
This is in the context of ICSID.
Yes, it is. But it's just yet another source on which one might draw the weight of his supremely a matter for my lords, to ask and answer the question of what is the sort of language one should be looking for there to be a consent to execution by Libya in clause 32, read into clause 32. Yes, it's a slightly different context. But the general.
I was wondering whether you were going to rely upon ICSID more generally, and the distinction which is drawn there between enforcement and execution.
Well, I don't think we need to, but of course one's familiar with the fact that ICSID is constitutionally or institutionally concerned with the position of a state and is formulaic in its approach, as is captured in this article, to questions of enforcement and execution. I don't think I need to go there. We haven't in our written submissions done that.
It might support your argument that the reference to enforcement doesn't include execution.
It would, but we don't think we need that. We think that is obvious, that enforcement and execution are two different creatures. And go right back to the start of the first authority I took you to and the judgment of Lord Justice Moore-Bick. And execution is a creature of a very different colour. My language, of course, and not
Section 13 uses the word enforcement.
Yes. But if one looks procedurally at the position, we have a situation, I was going to come to this in a moment, I'll deal with it now, where if you track through what has happened in this case, you have the award in January 2016, then in 2018, an application is made to the court under section 101, subsection 2 of the Arbitration Act for relief, described by Lord Justice Moore-Bick rightly as the basically the last act of the arbitral process. That is the end of enforcement. And then one moves into a totally separate phase as regards execution.
Well, I think that phase is referred to as recognition, isn't it?
Yes. The first phase is, yes. Which is where the
There's a quite long discussion of recognition, enforcement and execution in the High Court of Australia decision in ISL, isn't there?
Yes, which we'll come to. There is. And in our submission, this is all helpful from our perspective, particularly when one then considers how in this case the language used, and this is in the schedule to the end of our skeleton argument, you will have seen that we have lifted out several of the cases and the language that is used in those cases to capture the concept of or examples from English case law, which are where the court has had to wrestle with this or similar issues. And in all of those cases, Republic of X, Sabah Shipyard, Pearl Petroleum, Deutsche Bank and Venezuela, all have expressly used the words waiver, immunity, assets and or property, in contradistinction to what we have here.
If you're right in your submission that it requires clear words, it's not just a question of interpretation of the contract, it's a question of clear words, then I understand why these are relevant. If you're wrong about that, and it's simply a question of interpreting the contract according to Swiss contractual principles, why does it matter that it could have been clearer than it in fact is?
Well, if the
Well, here's that argument in almost every dispute about interpretation of contracts. Well, if you'd meant that, you would have said so much more clearly.
Yes, if the Swiss law requirement is a requirement for express language, I'll put it as neutrally as one can, and the Swiss law interpretation of this contract, done by His Honour Judge Pelling, with precious little assistance, was that should have been that the language in this contract doesn't meet the Swiss threshold, and I completely accept the rest is OTOs. And one wouldn't need to worry about it. The need for clear language comes in at the English law stage, in that if you have my lord knows. Thank you very much. Can I? I'm looking at the time. I got rather behind the clock. I'm sorry. But I will finish in 16 minutes. Language and proper interpretation clause 32. Our skeleton 38 to 40. Their skeleton 60 to 64. If we go back to the clause, which you don't need to, and turn to the language and proper interpretation of clause 32. This serves as an echo from my point right at the start, which we have been covering much of the same ground of, in how one looks at what this clause actually means. In the interest of time, I'm not going to repeat the 6 points I made right at the beginning, because my lords will have them, but they apply under this heading particularly now. I'm going to move on to the fourth and last substantive point on the second ground. And it's this, which is that the wrong approach was taken to good faith and surplusage. And this is a difficult point forensically, because it is so surprising that such an experienced judge should have indulged in the analysis that this judge did. It is common ground, and was before the judge, that no objective of interpretation of in good faith applies in Swiss law unless the wording of the contract and the evidence of the parties' subjective intentions is inconclusive. However, there was no evidence before the court as to what good faith means in these circumstances. GD UK accepts that there was no such evidence and concedes further in paragraph 35.2 of its revised skeleton. After the judge and the court below asked both parties what the concept meant, neither could answer. But the judge proceeded at paragraph 13 to, and I don't mean to put this in any way disrespectfully, but invent his own concept, albeit, as he says, with some hesitation. GD UK seeks to defend the judge's approach by deeming this an objective interpretation of good faith, but such ambitious rebranding provides no support for what the judge did with respect. What the judge did was he created or confected an artificial approach which moves on at paragraph 15, i.e. that good faith interpretation of the contract gives rise to the conclusion that he there expressed. Not only was this interpretation of good faith a pure invention of the judge's own, in the absence of any foreign law evidence on the point at all, and in the face of the party's inability to determine what it meant or give any guidance on it. But it was also independently flawed in that it seems to have flowed from his incorrect starting point, namely that the contract reflected standard commercial transactions between commercial entities. It is, with the greatest possible respect, not acceptable for a judge to invent a concept of foreign law. I hope I'm not being too harsh in saying that, especially there was no English precedent for such a concept. And it really is unsatisfactory that he goes on to then use the concept that he himself has formulated to bolster his own findings, what we say is already incorrect reasoning. And one of the aspects of this was whether the court should strive to find a meaning of the final words in clause 32, which avoided the concept of surplusage. I suggest that there is no such requirement and that the judge was wrong to, in effect, apply one, as are Millennia Friends in their appeal skeleton. After having accepted correctly that there was no presumption against surplusage, the judge appears to have then reintroduced such presumption by the back door in what he termed Swiss good faith. But the back door was never open to him. One looks at his paragraph 17 in his judgment. He typifies Libya's case as the entire final sentence is surplus because it adds nothing to what the parties have expressly agreed in the third sentence of clause 32 of the contract. In my judgment, construing the final sentence of clause 32 as being devoid of all content is unlikely to give effect to the intention of the parties, viewed from the point of view of a reasonable person with all relevant knowledge applying the good faith principle. And there it is again. So though the judge again purported to apply the unexplained good faith principle to the contract, it appears that he was simply applying the so-called presumption against surplusage by another label, which is mistaken in three respects. First, having observed correctly that there was no evidence of Swiss law before the court that addressed the principles on surplusage, any reasoning on it should have stopped there. No basis for assuming any such principle in English law applies to a Swiss law governed instrument. But unfortunately, the reasoning didn't. Second, even in English law, the so-called presumption has repeatedly been held to be of little value to the interpretation of commercial contracts. The Eurus case, Total Transport Group, is an example in point, which I don't take you now given the time. Numerous such judgments have noted it is common for commercial draftsmen to adopt what Mr. Justice Hoffman called, as he then was called, linguistic overkill to try to obliterate the conceptual target by using a number of words or phrases expressing more or less the same idea, a concept which all lawyers are all too familiar with. And third, the judge was wrong to say that Libya's primary case, as to the meaning of the final sentence, added nothing. Libya argued below and continues to argue that the parties agreeing an award, which can be wholly enforceable, means the meaning I gave to it right at the very start. The judge appears to have assumed that such enforceability is implicit in an arbitration clause that does not mean that clause 32 was mere surplusage. Rather, by making an implicit statement into an explicit one, the parties sought to remove any doubt, which is a common drafting technique.
What the judge does in clause 18 is he refers to section 9 of the SIA and says, in England, you have section 9, and therefore the words wholly enforceable must apply to something else. Of course, it doesn't apply only to England, it applies to all jurisdictions.
Yes.
So I'm not sure that works.
No.
So I don't know if you say they're not surplusage, they mean enforceable in the exit sense.
Yes, res judicata.
Well, enforceable in the sense that it can be enforced in any jurisdiction.
Exactly so, yeah, which I'm just going to come to. And
It can't be executed.
Yes, exactly. Exactly.
Which is different.
It is.
That's your point.
It is my point. And I'm just going to finish, if I may, by coming to the very point that my lord was just making. That one has to look at the wider context here. That before the court below and GD UK in its submissions make much of the alleged unfairness of GD UK being provided with no actionable remedy if execution against the Hampstead property is refused in circumstances where the parties agreed a commercial contract. However, this approach failed to take into account three things. First, and to reiterate, General Dynamics is one of the world's largest arms companies. It was making a deal with what was then the Gaddafi administration of Libya. It went into this contract with its eyes wide open to the risks, and if it failed to secure what it considered to be adequate protections as a matter of English law, then so be it. What they hold is a worldwide enforceable remedy, which in another state, as I come on to say now, may well advantage them. Because secondly, it must be recalled that GD UK has secured an international arbitration award against Libya, which is capable of recognition and in theory of enforcement in multiple other jurisdictions. Simply because it has failed to meet the requirements of English law as to state immunity does not mean that GD UK is left without any recourse. If, as GD UK suggests, their legal systems, other legal systems have more lenient approaches to a waiver of immunity than does the UK, then perhaps GD UK should consider enforcing against assets there instead, because none of this can save them from their own position under the law, the words of this contract. And third, and as I've already mentioned, GD UK has concluded in its skeleton it would be able to apply to enforce an award against the commercial property of Libya in any event. So any unfairness or absurdity arising from Libya's case is on close inspection nothing of the sort. And subject to anything I failed to deal with, those 6 minutes short are our submissions.
Thank you, Mr. Lewison.
Thank you very much.
Well, you've got an extra 5 minutes, Mr. Goodhart.
Thank you, Lewis. My lords, the sole question for the judge below was whether on its proper construction, clause 32 of the contract amounts to written consent for the purposes of section 13(3) of the State Immunity Act. Lords, when I say that and formulate it in that way, I am in fact only repeating what Libya itself told the judge below. If your lordships would take up the supplemental bundle, tab 1, page 6, this is Libya's skeleton in the court below. Bundle page 6, paragraph 9. The sole question for the court at this hearing is whether on its proper construction, clause 32 of the contract amounts to, quotes, written consent, close quotes, for the purposes of section 13(3) SIA. The judge decided that question, the only question that he was asked to decide, and he decided that clause 32 of the contract on its proper construction under Swiss law, applying principles of Swiss contract interpretation law, did amount to written consent. Our submissions on this appeal are as follows. First, in relation to the only question that the judge was asked to decide, the answer he gave was right. On a proper construction of clause 32, Libya, by prior agreement, gave written consent to the issue of process for the enforcement of arbitration awards made pursuant to the arbitration agreement in clause 32, thereby satisfying section 13.3 of the State Immunity Act. Libya's agreement that the decision of the arbitration panel made pursuant to the arbitration agreement would be, quotes, wholly enforceable, was written consent to, in the words of section 13.2, the property of the state being subject to any process for the enforcement of a judgment or arbitration award. And the judge, applying the common ground, I'll come back to that point later, the judge applying the common ground Swiss law principles of contractual interpretation rightly so concluded. The judge rightly rejected in paragraph 16 the alternative construction of the words wholly enforceable that was contended for by Libya below, and Libya does not pursue that argument on appeal, and so must be taken on this appeal to accept the judge was right to reject that contention, the alternative meaning that Libya contended for below. Pausing there, that means that Libya's appeal in this court starts on rather stony ground. The judge did decide the question that Libya told him was the only question for him to decide, and as between the rival answers to the question presented to him, Libya accepts that the one that it contended for below was rightly rejected. So, in fairness to the judge, it should be pointed out that whatever the merits or demerits of the arguments that Libya now seeks to make in this court, the judge cannot be criticised for not addressing them because they were not made to him. And it is somewhat harsh, if I may say so with respect to known friends, somewhat harsh of Libya's new legal team to present its new arguments as setting out respects in which the judge is said to have failed to do something or erred within his judgment. Secondly,
can I just pause a moment? The first ground of appeal, which as I understand it, the judge gave permission when the old legal team or former legal team were acting, does raise the question of clear words.
my Lord, yes,
And the judge gave permission for that.
but, my Lord, what the judge was told on the permission to appeal application was that that was an argument of construction of the contract, not a question of statutory construction. And Lord, you can see that the references are in, I think, footnote 3 of our skeleton, but I can quickly show you that, Lord, at
Say supplementary bundle, tab 17, page
Tab
196.
and if your lordship will look on, so bundle page 196, at the bottom of column 1, so this is internal transcript page 2, line 25, going to the meat of it, my lord, ground 1, the court erred in holding that clear words are not required for a state to waive its immunity from execution or providing written consent for the purpose of section 13 of the State Immunity Act. I should make clear at the beginning of this submission that to succeed on this ground, I do not need to establish that commercial contracts between a state and a private party fall into a different species of contract from other commercial contracts. The proposition that clear words are required before the court will hold that a party has abandoned valuable statutory rights can be analysed as an incident of the court's approach ordinarily to the construction of commercial contracts. And then over the page, bundle page 197, internal transcript page 7, line 17. My lord, what I've attempted to show you already this morning is that I don't have to go any further than that proposition because the clear words principle is a facet of the ordinary approach to commercial contracts where proceeding and entering into the contract, the parties have an asymmetry of rights by virtue of statute. ground one, my lord, can I turn to two? Yes, well, the court.
So that's the Gilbert Ash principle.
That's the Gilbert Ash principle, exactly. And, my lord, that is the difference between Libya's position below and in this court. It is because that difference, in other words, changing ground one from raising a question of construction as a matter of, it's not said English law, but that's what it appeared to be, to one which is now put in, as your lordship would have seen in the revised skeleton, the new skeleton, purely as a question of statutory construction.
Yes.
But it's because that is, we accept a question of law, a pure question of law, that as we've indicated in our skeleton, we are not objecting to it. My lord's second submission on exactly this point, the new argument, Libya is wrong in its submissions on appeal to suggest that section 13.3 as a matter of statutory construction imposes a separate and additional requirement or condition for what needs to be stated in a prior agreement for there to be written consent. The statute does not prescribe such a condition or requirement. There are no words in section 13.3 which prompt the interpolation of such a condition or requirement. Indeed, the proposed interpretation of section 13.3, there is a requirement that there be clear words of waiver of the right to immunity, would be inconsistent with the language of section 13.3, which states that consent, it's authority bundle page 12, section 13.3 states that consent which may be contained in a prior agreement may be expressed so as to apply to a limited extent or generally. And then it goes on to provide that a mere submission to the jurisdiction of the courts is not to be regarded as a consent for the purposes of the subsection. If the draftsman considered that a mere submission to the jurisdiction would otherwise satisfy the requirement of consent, or might be thought to do so, and that should be carved out or clarified for the avoidance of doubt, it cannot have been the intention of the draftsman that there should be read into the first part of the subclause requirement for the use of certain specific words such as waiver or sovereign immunity in the written consent. A mere submission to the jurisdiction would not contain such words. So, put another way, if Parliament had wanted there to be such an additional requirement, the draftsman could and would have included it, and had such requirement been spelled out, there would have been no need for the proviso. To find such an additional requirement or condition posits the absurd possibility that even if on a true construction of the prior agreement under its applicable law, Libya consented to enforcement of the award against it, nevertheless, it may be held that for the purposes of section 13.3, it has not. The correct position as a matter of law and on the authorities is that the question whether there is written consent in a prior agreement is a question of construction of the agreement under its applicable law. There is just the one question, as Libya was right to tell the judge below, and it is one of contractual interpretation. There is no additional statutory requirement, and ground one in its new emperor's clothing is wrong in its premise. that there is any question of statutory construction, and it is wrong in its proposition that section 13.3 contains an additional requirement. Third submission, Libya is wrong to suggest that the words wholly enforceable have no meaning, or when pushed to say what they mean, Libya says have a meaning connected only with recognition. Recognition and enforcement are different, distinct concepts and are treated as such in conventions. The New York Convention, obviously being a good example. In fact, going back to the 1927 Geneva Convention, I'll show you, your lordship, a reference to that in the commentary, but also in statutes, including our own Arbitration Act. If it sounds rather simple and trite to say that the words wholly enforceable must have something to do with enforcement, then perhaps that is because it is simple and trite. Libya's promise that any award against it made under this arbitration agreement will be enforceable means that it consents to the award being enforced. That is the short answer to the appeal, as it was the answer for the judge below. Though Libya offered him below a different, but we would say equally bad, alternative interpretation of the words wholly enforceable.
You'll come presumably to the question whether there is a difference between enforcement and execution.
Yes, can I mention that straight away, only because I'm going to give my Lords, if I may, a short answer to that point, the point identified by my Lord Justice Phillips in relation to the discussion in infrastructure. And I would certainly welcome being told if the answer I give is actually not a complete answer to it, then I would want to address it further. But can I just show you in infrastructure and in the discussion in my Lord's judgment in relation to High Court of Australia. So this is in the bundle of further authorities, tab 6. And the first point to note, because we're talking here about, and of course considering the ICSID Convention, on page 284, the first point to note is that the distinction between recognition, enforcement, and execution is a distinction which arises because of the scheme of Articles 53, 54, and 55. And could I just ask my lordships, my lords, to remind yourselves of those provisions. Article 53, first, Article 54(1), Article 54(3), reference to execution, and then importantly, Article 55, nothing in Article 54 shall be construed as derogating from the law in force in any contracting state relating to immunity of that state or of any foreign state from execution. And one sees that carve-out shows one, even just starting there, that what is being provided for is a different provision in relation to, and a different treatment of the position in relation to execution as a carve-out from enforcement. In other words, recognizing that execution would otherwise be a part of enforcement. Now that issue...
I'm not sure that sustains reading the Travaux Operatoire and the High Court of Australia analysis, does it?
the short answer, the short answer I was, can I just, if your lordship, just bear with me a moment.
Yeah, of course.
If we then look at, if we can just look at your lordship's discussion of the point, but also the High Court of Australia point. Paragraph 74 of the judgment on page 305. Which I think must be the passage that your lordship had in mind when your lordship asked my own friend the question. So the reference there in paragraph 74 to the High Court of Australia stressed that the convention used the terms recognise, enforce and execute to denote three distinct processes. And then in paragraph 44 of the High Court of Australia judgment, the further distinction between recognition and enforcement on the one hand and execution on the other hand is then drawn out in Articles 53 to 54 and Article 55. This is seen in the provision by Article 54.3 that execution is a matter to be governed by the domestic law of the contracting state, and so on. By Article 55, none of the international obligations extend so far as to derogate, etc. So, my lord, my short answer to the point in relation to that distinction is that that is not a distinction between enforcement and execution, or a delineation or a carve-out, which that is particular to the scheme of the ICSID Convention and is not a scheme which finds, or a set of distinctions that one finds reflected in the State of Libya. In fact, to the contrary.
But does that matter? Sorry, we're not looking at the state of immunity now, are we? We're looking at the contract.
Indeed. And the only word used in clause 32 is enforceable. And I would say, even without the word wholly, enforceable is a term that would naturally have a connection with enforcement, not in some narrowed or carved out way in relation to enforcement generally. The addition of the word wholly makes it, in our submission, clear that it's...
Well, I suppose the point, and although I think this like said several times he would come back to it, I don't think he ever did. But I suppose the point is this, looking at a convention between states and the way it's been looked at by the High Court of Australia and that Court of Appeal, it certainly gives rise to a question as to whether or not the use of the term enforcement against a state is intended to encompass execution, or whether it is only intended to encompass enforcement in the sense that it is used in the ICSID Convention. And there it gives rise to at least a question of uncertainty or ambiguity, doesn't it?
But in the ICSID Convention context?
Well, absolutely, that's the convention, but of course the ICSID Convention isn't something which is dealt with in isolation. As one sees, it is dealt with by an extensive negotiations between states, all of whom wish to ensure that by agreeing to enforcement, they were not agreeing to execution.
So my first point in relation to that is that the ICSID Convention, with its special scheme, is not the place that one would look to in order to understand what parties in a commercial commercial agreement with a state would mean when they use words that have enforce as the root. The very fact that
Well, I agree. one wouldn't immediately say let's look at the exit convention, but it is illustrative of the fact that when a state in particular is entering into an agreement, it may have in mind that there is a distinction between agreeing to enforcement and agreeing to execution, and it might be prepared to agree to enforcement and not prepared to agree to execution.
Of course, Lord, it is possible that a state might so decide. But in so deciding, and if that was what was negotiated and agreed, there would have to be some language which works on the basis that something that would otherwise be comprehended by enforcement, namely execution, is not being agreed and is to be carved out. And
Well, I suppose that depends which way around you look at it, I suppose, doesn't it?
well, to look at it the other, I'll come at it the other way around. To come at it the other way around involves saying that the starting point in relation to enforcement, in relation to the meaning of enforcement, is to look only at something which is preparatory in the beginning of the process.
Isn't that what we have to look at as a matter of Swiss law then?
My lord, yes, but it's or that the judge had to look at applying the principles of Swiss law. The Swiss substantive law of immunity point is a.
It seems to me at this point the State Immunity Act doesn't help us, does it?
No, I agree. I entirely agree. We're looking at a question of construction.
Neither do any of the English authorities.
I agree, but that is a point that pushes against trying to construe the word enforceable to refer to something which would ordinarily just be one type of preparatory act of enforcement, namely I can put it in civil law terms, the obtaining of an exequatur, which would be the equivalent of an application in England for permission to enforce an award as a judgment. But to describe, to say that to ask the question whether the word used, a word that has enforce as the root of it, in a contract, is referring only to that particular type of enforcement process. It doesn't matter whether one starts, as it were, there, or from where I would say is the more natural way to start, which is that the use of the word enforcement would most naturally cover any type of enforcement that there could be of an award.
As a matter of Swiss law. And was there any Swiss law about this?
About the meaning of enforce?
The concepts in Switzerland.
No.
Execution.
Not in relation to enforcement processes. Not in relation to enforcement processes in Switzerland. But my lord, on that point, I would submit that those would not have been relevant to the construction of clause 32, because
Well, we've got to understand what the contract meant when it said wholly enforceable.
yes, but it must always have contemplated the possibility that an award could be enforced, or there may be attempts to enforce an award in any jurisdiction. So there can't be anything, just as it's not relevant to look at the particular language in the State Immunity Act in order to interpret clause 32, so I would submit it wouldn't have been relevant to look at particular processes of enforcement in Switzerland in order to interpret clause 32. Clause 32 has to be looked at not parochially in that context, but in circumstances where, as I say, enforcement could take place anyway. It's for that reason, my lord, that I would say that when one's talking of concepts such as recognition, enforcement, and execution, it is more relevant to look, for example, at the New York Convention, which is a convention on the recognition and enforcement of awards, rather than the ICSID convention.
Shall we come back to this at
I'm
2:05?
sorry,
2:05.
All rise,